Rishita, you can start now.
Sure, ma'am. Good morning to everyone present here today. I, Rishita Tripathi, is the host for today's panel. It brings me an immense pleasure to welcome you all to the Global Virtual IP Summit 2023 on behalf of entire team of IP Assisto. Now, I would like to invite Ms. Mehak Rathi ma'am.
Thank you, Rishita. I would like to thank you all for joining us today. The Global Virtual IP Summit is being organized by IP Assisto to celebrate World IP Day, which is observed on 26th of April. This year's theme is Women in IP. And as Raghavendra sir highlighted in the inaugural session, that only 18% of the patents which are being filed are by women. So I'm very sure there is an awareness which is needed. And with that, we have scheduled various panel discussions and workshops for next 2 days on various aspects of IPR. And I'm sure that with expertise of our panelists and the speakers joining us, it will be a great learning experience for all of us. IP Assisto was established in 2019 with Dr. G.R. Raghavendra, former Joint Secretary, Ministry of Law, as our patron. Vision behind setting this initiative up was to disseminate and spread awareness about IPR in India. Over a period of 3 years, we've conducted various sessions on different aspects of IPR, and we have not confined ourselves to the legal domain only because IP and innovation is everywhere. I won't take much of the time because all our panelists are here, and I would hand it over to Rishita. Thank you so much for joining us today, and I'm looking forward to a great learning experience from this panel. Over to you, Rishita.
Thank you, ma'am. The topic for our panel is trademark law in the age of social media. Our esteemed panelists for the session are Mr. Rohan Radgi, sir. Sir is the founder of RSR Legal. Dr. Abhimanyu Chopra, sir. Sir is the partner in AZP and Partners. Mr. Subhash Bhutoria, sir. Sir is the partner in DSK Legal. Our moderator for the session is Rishabh Srivastava, sir. Sir is the principal associate at Ragal Law. I would like to thank our panelists for taking out their time to join us today. I am sure that it is going to be a great learning experience for all the participants. Now, I would like to hand over the stage to Rishabh, sir.
Thank you all for the joining. As we all know that in IPR, the trademark is one of the very crucial rights which has been accrued to the person who wants to protect its brands. The dynamics of the trademark law has been evolving in this field. And I have seen it evolving more with the coming of the social age of social media, where the social media influencers are there, there are the Twitters, tweets, then there's disparaging issues. So there are a lot of issues which are coming up in this age of social media. A new branch has cropped up of social media marketing, where we can see the meta tags, etc., which has been there, which cannot be seen. So there are a lot of infringement issues which have been there in this current age of the social media, which needs to be sorted out, which needs to be seen. So I would like to start with Dr. Abhimanyu, sir, to give us a brief overview of trademark disputes and its changing nature, and how the IP litigation is continuously evolving and developing to meet these challenges. Sir, please.
Hi, everyone. I hope I'm audible.
Yes, sir, you're audible, sir.
Thank you. Greeting of the days to my fellow panelists, organizers, and the audience. I'm pleased to share the virtual dais with my esteemed fellows. I'm delighted to share my thoughts on trademark law in the age of social media, balancing free speech and brand protection. I am hoping that this session will surely serve as a delectable dessert for the mind. So let me start off with a brief overview. Trademark, or rather IP disputes, have come a long way in India. If I give reference to the Delhi High Court and the Madras High Court, we've even seen that they have started off with new IPD divisions, which are the intellectual property right divisions, which have created additional points, additional specialized bench, a specialized judge who will hear such matters. So let me break it down into four buckets. Initially, IP litigation in India was or usually called as luxury litigation. People did not understand why protecting a right under law which pertains to intangibles is really important. However, the more we have grown, we have seen this is no more a luxury litigation. It is a tangible business, viable, and action taken both for brand protection, brand gating, and to enhance the brand overall in India and abroad. So it is just not meant to go from a individual IP infringement based actions. They have actually gone on a global scale where IP rights, bouquet rights protected in India are given the same status outside. So if we take an example from the John Doe orders regime, where for the very first time, Ashok Kumar order or John Doe order or Minerva Mill order, whichever you would like to refer it to as, was passed by the High Court where we did not know who the infringer was. The infringers range from anonymous John Does across India, could be abroad. With globalization of internet, it's not even a localized or a individual right; it's a more of a global right. And now the regime has moved on to dynamic injunctions, where torrents of unknown origins are also blocked. What I really like in the regime from say the last 20 years that we have evolved to a situation that we don't really have to find out who the person is. For a brand, doing a background investigation in such matters is a very important and a very difficult exercise because normally these people are not available on a physical designated addresses. Personally, I have done matters which involve a lot of man hours in finding out where the infringers or how the mechanism of these infringers are. So the new dynamic injunctions which have come in are a very welcome step. I was referring to the IPD, so I'll take the example from the Delhi High Court because it started it first. The Delhi High Court has an IPD division where they are not only a specialized rule of intellectual property rights, but there is also a designated three-court bench which will actually hear these matters. Three independent judges doing independent matters in a day, around 50 matters a day, around 150 matters that they do, and where regularly John Doe orders, dynamic injunction orders are passed. And most importantly, what has also started is it is now for the infringer to really suffer the rigors because now it's putting your money where your mouth is. If you're presuming that your right under law is not infringed and whatever you're doing is under the garb of free speech or is it normal, then you are also subjected to actual legal costs. Personally, working on the regime, I have seen that if people are spending or if clients, litigants are spending money into this litigation for the aspect of deterrence, these actual legal costs really help. Under the original side rules, chapter 23, read with rule 35 of the IPD refers to this. Uh, Another welcome step is the new CPC amendment, which is coming in, where 39 2A orders are also applicable to third parties. So when you look at from a holistic view, I would say the regime is evolving, where courts are also finding out specific mechanisms how to enforce their order, whether the orders are global or in India. Now, coming and taking this to the social media angle is something which is both a boon and a bane. Social media in today's day and age is not something which it started with in 2007 on 2004 when Facebook came in. I don't think so. Our forefathers in the constitution really thought that internet would be something which would actually hamper or dilute or enhance such rights, which includes Article 14 and Article 19 of the constitution. But when you see in today's day and age, I would take example of say Instagram or Facebook or even YouTube for that matter. It's become a world of reels. It's become world of connecting over a click of a button. When you do this, the businesses have no option but to follow through. If they don't, then they'll be left behind. If you are on TV and people are watching OTT, then you will never do ads. So similarly, you have to move where your audience is. Now, with social media coming in, this also puts in a lot of rigors for people who are actually providing such services. The influencers have been given some sort of responsibility under the new ASCI rules, which I'll just discuss in a moment. So let's say if you are a public person, there are individuals, there are aspects which are being dealt under Instagram lives or under the model of social media. You have to also see that such actions are not just a means to connect, but also to promote one's business ideas and give visibility to one's products and services amongst the public at large. Given this easy access in the 21st century, all thanks to the vast technology advancements, unauthorized and illegal usage of brand names and trademarks on social media has become an ever growing menace. Firstly, dealing with matters where we have actually sought injunctions against entities which are destroying brand value, diminishing repute, and just servicing counterfeits in the market. The clients and the business has no other alternative but to fight it out. The easy access to trademarks, logos, words, phrases on social media platform has given room to the proliferation of unauthorized uses of trademark and brand names in the digital space. Such proliferation may be in the form of brand jacking, cyber squatting, or even disparagement, which can potentially lead to a catastrophic devolution of trademarks, which results in loss of customers who may over the other competitors which offer similar products and services. Now, let me explain what is brand jacking. Brand jacking is when something or an unauthorized person takes over someone's online entity by some other person. There have been a lot of cases of brand jacking recently in India. The one of the very first cases was when Yahoo had actually sued certain individuals who were found running on infringing domain names, which was deceptively similar to Yahoo. And considering the usage of Yahoo at that stage when domain name and every email ID had Yahoo in it, the Delhi High Court came down very heavily on the infringers. And they not only injuncted the infringers, but also subjected them some heavy duty costs. Another interesting case, if we take US for example, was in the public relation case known as Tanner Friedman, where there was a fake Twitter account created by a name, which actually became a lot of embarrassing tweets were made from this particular entity. Recently, I came across a meme also, which is entity which used to care customer care logins of a brand. So imagine if you have a brand such as McDonald's or something like Wendy's, there was an account which would make itself called as customer care, and it would actually demean the brand. So while it got a lot of outrage on Twitter, some of the actions also led for those companies to actually file a case against that Twitter handle. So while you have to see that the idea of free speech is clearly there on social media, it is not subject or it is subjected to 19.2 of the Constitution for limiting such free speech as well. On a lighter note, I don't know if people would have seen the recent cyber squatting action where Kanye West actually had one fine morning found out about a Twitter page in his name, which actually had a lot of rants which went viral and turning out to be a treat for the paparazzi. The fake account was finally suspended due to strange activity, but there was never a formal case filed. Now, when we look at disparagement of a brand, keeping from an Indian standpoint, disparagement has become a very big issue. When disparagement is now not only, I would say, it's two centric. One, if a competitor really takes or hires a social media channel to actually disparage the brand on or off the record, or the brand itself does it. So we've seen a lot of disparagement, sometimes in healthy banter, sometimes not. We've seen the Zomato, Blinkit, and the Swiggy ad campaign which is going on, which could be a healthy competition as long as nobody really disparages somebody. But when you also look at disparagement from, say, a YouTube standpoint, we have recently seen cases before the Calcutta High Court, Madras High Court, Delhi High Court, where an action, when it is used to, say, devalue brand names, disparagement is really made out. In one of the cases, which was against a leading FMG manufacturer, not naming any entities for the sake of good explanations, we saw that a individual who had a YouTube channel which contained denigrating and disparaging remarks of one of their products, the brand got completely outraged by this. They not only sued him in by sending out a legal notice, they also went to the Calcutta High Court. And the Calcutta High Court, in a very big 180 odd page detailed reasoning judgment comparing US Indian standpoint, containing and explaining the freedom of speech, the aspect of limitation in the 19.2, along with Article 14 arguments, and looked into this feature and said that the FMCG company is right. Such actions done by the individual on the YouTube channel was definitely disparaging. And they actually came down heavily over the said influencer and directed him to remove such offending portions from the video. Another classic example of disparagement over the internet is where another social media influencer just recently posted a social media on platforms regarding a particular nutrition value of a particular product, where it was alleged that the said product largely contains sugar, which makes children addicted to sugar. He actually showed the entire nutritional value from the packet and said that half of the packet of what you are looking at is just sugar. He also said some of these actions cause cancer. So this obviously led to a situation, because the moment things like these get viral, the brands have to take a legal action. They issued a legal notice, and the influencer basically came down saying that I've removed the post, that it wasn't meant to really disparage. I did not when I did not mean to, defame the brand, but I was just making a point. And therefore, he also posted an apology asking and requesting the brand to not really come after him. We've also seen similar cases in the Delhi High Court where brands have come down against individuals. But I believe that is a situation which is very fact centric. Sometimes influencers go overboard with how they portray or particularly state a certain subject. And it is also dependent upon what kind of a following does the social media individual has. I've really seen people also getting people to task by holding them to ransom, that if you don't agree to my demands. So it is both a boon and bane, I would say. For every good, there could be a better option, but people will then have to, continue following some kind of a template. With the new IT Act coming in, there are also restrictions on how social media influencers work. Under the ASCI guidelines, there is now how the influencer should work. Now, interestingly, the next most important thing which I have seen recently is the cyber financial frauds. With the reels coming on individuals who give financial advice, we have also seen a recent SEBI circular which has come in regarding controlling them. So, with regards to cyber financial frauds, it is just a few days back, Delhi police also arrested a group of people which uploaded fake customer care numbers of banks. Now, this has both trademark, IT, and it's kind of a little hobgobble in it. But when you look at IT Act and the Trademark Act, especially in the cyberspace, they now go hand in hand. An action in IT, or say Trademarks Act, or even Copyright Act for that matter, it's a little convoluted nowadays. And we prefer all actions to be put before the cops so they can properly investigate such issues. Now, how do social media platforms stop such menace? One could be that this could have some form of prohibited guidelines. Internationally, what we follow is the customer and the community standard rules, where people generally follow a particular stand and a particular standard, that if these criteria are met, it will be allowed to be displayed on the social media platform, until and unless somebody really flags it out, points it out, that it is in violation of so and so points of the community standard rules. To counter such measures, also most social networking sites on their policies specified that such kind of actions which is prohibited, which is impersonation of others, and the unlawful use of trademarks on their platforms are not allowed. However, because of the standpoint that they take the intermediary status, it is also a lot of time where people have to point out such actions to the intermediary and to the social networking websites, that this is being done on your website, please take it down. Pursuant to the Shreya Singhal judgment 2015 5 SCC 1, where I was one of the parties, where we had actually were successful in setting aside of 66A being unconstitutional, which was the most bizarre and the vague section under the act, where people would take benefit of a section and pretty much ask police to investigate. They could be arrested without warrants. So that something on those lines also has becomes important today, because that also gets now clarified regarding what is intimation to intermediaries, and whether such standpoint, whether they have a mechanism on their website, and how, and the process is basically devolved as to how they are supposed to take action. With the new digital media ethics guidelines, some part which is currently state, there are also now requirements that any significant social media entity which is a party or which performs services in India needs to have Indian employees the chief grievance officer, the chief investigation officer should be in India, so that the law enforcement authorities and everybody can really reach out. Now, coming point to our particular topic regarding balancing of free speech, we have seen that everything on social media is really available to everybody. I sincerely believe that while access to information, access to technology, access to free speech should be a fundamental access to everybody, but not everybody is qualified to at least make observations on the internet. If we have to truly make a balance, or if we have to truly safeguard ourselves, our children, and everybody on the internet, we have to see that the person who does this on a global level, does this freely, has to have some kind of a repercussion, have some kind of bare essentials to be followed. So we don't have a criteria that the information out there is menacing. It is should not be demeaning. It should not have an impact to another person in a manner that they cannot follow through. So if social media platforms really require, they should actually have some kind of an authorization for every use of another trademark. They can potentially hamper free flow of information and ideas. Therefore, it is always crucial to bear in mind that the third party may have a legitimate reason for using another trademark on the website. We can also look at from a context of videos, information being published should not have copyright violations as well. Who knows that the trademark term may be part of a first or the last person's name with how things are moving on. Now, when there is a scenario where a third party may have concurrent trademark right, a fair use defense, or a free speech interest in using that term in parody, in satire, in criticism, comparative advertising, news reporting, and other commentary, then obviously that is something which can be further crystallized. We have seen AIB doing satires, we have seen the outrage of sometimes how this works. So while we are not okay and ready for everything, I think things will eventually grow even in India using the global standards similarly to other websites. Lastly, I wanted to talk about specifically for the social media influencers who ought to exercise responsibility. It is important for them to exercise certain degree of responsibility with their posts on social media. In a recent decision of Mariko, the Bombay High Court actually identified social media influence as a nascent category of individuals who have acquired considerable follower base on social media and certain degree of credibility in their space. The decision also noted the need of imposing certain responsibility, keeping in mind the power they wield over the audience and their trust placed in them by the public. Now, just to take it off topic, if you would remember during pandemic, how good the social networking sites were where people would reach out for help. And there was chaos at that time where the state government started arresting people for their posts that they were not doing anything. It was a clarificatory order of the Supreme Court, which only came in that the police will not arrest people using social networking sites who are doing a action of saving people. While there were people who were selling medicines, which could be obviously considered menacing or violative of the law, but the aspect of helping a fellow being cannot. So that aspect is what I would believe is the balance that the Supreme Court made even in the time of crisis. So I think if the logical answer is if saying this, speaking this is going to cause harm without, and you know it for a fact it's not true, please do not do it. The ASCI guidelines is something which is now compiled for all posts published by influencers. The guidelines also affects responsibility of the disclosure and of content in posts of the influencer. And they also have guidelines which require them to take due diligence before engaging in promotional posts on social media. Now, given this understanding, it is highly likely that in case in future these people do not follow exercise caution, eventually we will see people start getting sued from either the mechanisms, individuals, because it is only the first person who needs to suffer a loss for these regulations, these clocks to really click in, be it under the SEBI regulations for financial advertising, be it for normal individual posts. I think with that, I'll take it to my other panel members to take their thoughts on this issue. And thank you everyone for this.
Thank you, sir. Thank you for enlightenment. On the issue of disparagement, sir, I just want to have your opinion on the fact that there's a lot of rampant culture of trolling nowadays. There are a lot of trolls, a lot of memes has been created, and that sometimes destroy the goodwill of the company. So in this current era, how a person can deal with the disparagement specifically?
see, disparagement again comes under two forms, whether it is a known evil or unknown evil. Trolling, like you said, is an unknown evil in Twitter, and you have to really go to Elon Musk not to give them a blue tick status for $8. But presuming that everything goes normal, I believe there will be time where they will also start changing their technology or ensure that if there is a paid promotion going on, the trolls do not have a vengeful language which causes an impact. I think it will be more of how like a healthy banter comes in where you are saying this, but look, I can also do this. Something to be in a positive rather than the negative line. But yes, when they are unknowns, when they are specifically, and we have seen this in a lot of criminal matters, where there are unknown people who will post something without any backgrounds and without anything, that obviously is, I think, subject to only court interventions where people can go to the court, get injunctions, get dynamic injunctions, like I said. The best fact of dynamic injunctions that I've seen is even when a person today gets a John Doe order, say against 15, 16 trolls on Twitter also, they can keep on modifying that list and the court does not have to spend time on it again. That is one of the findings which Justice Manmohan gave in the Torrance matter, which I believe is a very, and if people have not read that judgment, you should, because it really amazes you that a legal mind could include so much on technical knowledge, and it also gives you a safeguard that you don't have to come to my door every time. You can also take this to the joint registrar under the regulations, so you don't have to get troubled. So every time if you ask practitioners, both of my panelists are lawyers, they would know how difficult it is that once you have a list, you get that injunction order, and then you go back to the court for modification, because it is a task getting matters listed early on before the court. It's a task getting the judge to hear it again, because once you hear it before the judge, every human has his own understanding, not only of law, but even on the nuances of law, explanation of technical knowledge. So if once a person makes that particular mind, you cannot really modify his mind, or if there's a new person who's made out a contrary judgment. So it's a task, and it's always an uphill battle. Only once we get that benefit with us that we have secured an order, then you have to ensure that it's an effective securing for the client and not just a paper decree in hand.
Thank you, sir. Thank you for taking a time to be with us. Now I'd like to move to Subhash, sir. So, sir, in the present era, when we have seen that dynamics have changed regarding to marketing also, we have moved from traditional marketing to the social media marketing. What, according to you, poses a challenge in the era of social media marketing with regards to trademark laws?
Thank you, Rishabh, and very good morning to everyone. On a Saturday morning, everyone has joined, and in fact, I see Abhimanyu, Rohan here. Probably after this session, we'll be flocking to all the viral restaurants, which we keep seeing on Instagram. People are posting a lot of photographs. So social media has become newspaper. Social media is not just the pastry, but everything around us. We start our day by looking at what is happening in social, through social media rather, and having its impact on our life more than just a fun activity rather than a necessity these days. I think social media has become very integral, and as a medium, as part of our lifestyle, a lot of things are known to us, accessible to us through social media, which also includes all the who's who and all the knowns, brands, be it whatever marketing that people do through social media. So, and of course, because it's an intangible medium, everything that is on social media is somewhere related to intellectual property or of data of the content, which is in that intangible form. Now, when I look at social media ecosystem, I would rather want to dissect it into the aspect from the stakeholders. So you have accounts, you have people who are the user base or the fan base, and you have different endorsers, you have different collaborators. So it's a huge ecosystem that we are talking about, largely from the perspective of user base. It is we need to see that the brands, while they function as trademarks, they are also in a way protecting the consumer interest, the user interest. So when I talk about social media per se, the two aspects to it, when we look at from the brand perspective, is trademark law vis-a-vis the advertising law, the media law, the consumer protection law, right, and intermediary laws. So the use of trademarks, let's limit our discussion on trademarks as of now, is that it can be the account name per se. Now most of the brands, when when they have a brand, they would want to have the same account name, just like how it started with the domain names, right? So they would want to have the same account name, same username. They want to use hashtags. They want to meta tag, use all the for SEO purposes, so that wherever they are marketing their product or services, it is whatever is available on the internet. It is all accessible through one unique source identifier, which is a brand, and that is the whole purpose of brand in the internet age. Specifically, when I talk about Instagram, how it functions is that whenever we are we have visited the Apple store, so we'll click a photograph and we'll hashtag Apple India, Apple Store. We'll put all the account names, right? And it often happens that while we, with good intention, that we put at the rate Apple India, it is not Apple India's account. It is somebody else's account. So there are a lot of times it happens with us, that we end up, tagging someone who is not the genuine source, who is not the right source, but is someone else, a third party, a squatter. Now, this is very rampant these days, and there are several of these accounts. There's a lot of typo squatting they use. They'll use APLE India. They would know APL underscore India or something of that sort. And if they are the first one to to use that account name before Apple could procure that account name, because once it is gone, right? So then in that case, you have to approach the platform to do a sort of a infringement analysis, and then pull down that account and hand over to you. So it is, and it's very surprising that while social media is a new trend, to say so, but in our trademark law, since 1999 at least, we have the provision which stops infringing advertising, which can be utilized. These provisions can be used to stop uh, infringement in this manner. So if I put the traditional or the conventional law in today's perspective, I see that using a trademark for misleading advertisement, for disparagement, for unfair competition amounts to infringement, provided you are a registered trademark owner, or otherwise you have the relief under passing off, right? Because that's a tortious liability. And of course, misrepresentation is also a tortious liability. So when I use any trademark, knowingly or unknowingly, it's a trademark, but it's a brand. Also, it happens in the taglines. When I use it as part of my account name, as part of my username, as part of my hashtags, keywords, with the intention to reap undue benefit or cause a loss of revenue or profit or of reputation to the other party, to the actual user, then that amounts to violation. Now, violation, if there is a violation, you have several ways to stop it. And the first and foremost and the easiest way probably is to approach the intermediary, the platform per se, to pull down that violation, to strike off that page, to to restrict or to block that page. That is the one. That is first step. But yes, if you have say you have created a photograph which has gone viral on Instagram, but it is not your posting or your publication on the Instagram which has gone viral, but some third parties which has gone viral, and you see that there are hundreds of such post having your photograph, then in that case, you would want to approach the court and probably get injunctions of various nature, John Doe, be it dynamic, be it of so many natures. So that's a part of strategy that you have to probably you have to take as part of your strategy, that what is the right way and the most efficacious way and the most efficient and immediate way to stop such violation. Also is very important, not just from trademark perspective, is what I realize that on social media we have a tendency to use images and violate image rights. Every now and then we are seeing a lot of, in fact, a lot of cases, a lot of suits are filed in respect to image rights. So it is, in social media, it is not only restricted to brand use of brands per se, but also other forms of IP, which are not even recognized IP per se. We don't have sui generis law for personality rights or image rights or publicity rights. So we are also seeing a lot of violation of image rights, celebrity rights. Whenever we go and watch, say, Pathan movie, right? And we all started, posting about Shah Rukh Khan's, images and Pathan. And then suddenly there are a lot of companies which started coming out with advertisements, which had, say, some meme around. In fact, I remember there was a meme on DDLJ. So that Simran's meme that she's, being chased by Shah Rukh Khan, she's in the train. And so when it is for a fun purpose, when it is more of a fair use purpose, where it is a parody or it's a meme, it is fine. But as soon as it crosses that and become a commercial proposition, then it could amount to violation. It could amount to infringement. Yes, it is infringement, but yes, there was a defense in fair use to say it's a parody, it is private use or something like that. But as soon as it becomes a commercial use, where you start showing your product being carried by Shah Rukh Khan, and he's trying to hand it over to Kajol, then it becomes a different thing altogether. Rohan would understand. so so it's very important for us to understand from the perspective of consumer rather than the brand owner when it comes to social media. And whenever we are strategizing on our presence on social media as a brand owner, then you have to keep in mind the consumer interest. And that is also, very interestingly, at least the trademark law, it goes hand in hand with the consumer interest. So when we read our infringement provision, it says that somebody using a similar mark or identical mark in relation to goods or services, which causes public confusion. So public confusion is a very important aspect even to trademark law, which is primarily made for trademark owners. So when I read public confusion in light of the consumer interest or in light of consumer protection, then I see that in social media parlance, both trademark law as well as the consumer protection laws, the advertisement laws, they have to be taken into consideration whenever we are strategizing our presence on social media as a brand owner. So, for example, if I'm advertising for, say, Apple phone, and in hashtag I'm Apple, I'm not very well known, but I know Samsung is something which is very well known in the market, a global market leader. I am advertising my about my phone. I have put in a ad, and I use hashtag Samsung, or I use hashtag which is a tagline used by Samsung, or something of that sort. So that is, again, it's a misleading advertisement, and that could amount to violation. Secondly is about surrogate advertising. So I'm a liquor brand. I am advertising about a water, a still water, or a sparkling water which I have manufactured or probably I'm marketing. In hashtag, I also mention about my liquor brand. Somewhere I'm doing a surrogate advertising. So from the perspective of advertising law, from the perspective of from surrogate advertising or misleading advertising, it needs to be seen that even the use of hashtag, which is also sort of creating a passing off, or sort of the use of hashtag per se is also a trademark use. And any such use of hashtag could also amount to infringement. So while people say, no, look in your ad or in my ad, I have not used your trademark or your brand per se. But if in the post, if there's a hashtag which is used, then that could amount to trademark violation. Similarly, that's quite visible. Hashtags are visible, but then there are cases of meta tagging and keywords, and we all have a plethora of judgments, and the celebrated judgment in India, which is of DRS Google, where keywords are also recognized as trademarks, which is invisible. Now, when you use for your SEO purposes, you are a new entrant, you are a startup, and you know that you are going to compete with all the heavy hitters here. You start using the keywords, which are not just the descriptive keywords, but also the brands. And very interestingly, when we were doing the DRS matter, we realized that Google had the biggest revenue churner for Google is the keyword, the AdWord services. And when we were doing this whole exercise of doing the AdWord searches, so if you search for say watches, so it'll show a list of keywords which are the most used keywords in Google searches. So it'll show Omega, it'll show Rolex, it'll show, and they'll say that you can bid for them. So while the descriptive keywords are also there, but also the brands are used as keywords. Now, as and when, because the use is very broad definition under trademark law. So as soon as you use the brand as keyword, it amounts to infringement. The question in the DRS matter was whether Google is also a joint tortfeasor or not, is something to be decided. But again, you have contrasting judgments across globe about Google AdWords services. So there cannot be a uniform understanding of intermediaries' liability in terms of keywords per se. But when it comes to a brand owner using XYZ's brand as a keyword, that would amount to infringement. So as part of the strategy to stay away from all these issues, the liabilities, and when the liability arises, it is not going to stay, inexpensive. Because if you approach Delhi High Court, you have to show that pecuniary jurisdiction is of 2 crores. And so every time you will be, the right owner will ask for a lot of cost and damages. So to avoid that expensive liability, also the embarrassment that you will face, and especially for startups, especially for MSMEs, which are progressive, which are promising, ventures, they should stay away from such liabilities and embarrassment by not using keywords which are brands. They should use descriptive keywords. And also, whenever they are advertising, they should not have misleading advertising. They should not use hashtags which are of their competitor's brand. They should not use, say, taglines which are of the competitor's brand. So these are a couple of things that they should consider while they are collaborating with influencers. And another interesting aspect is, when you're entering into contract with endorsers and influencer marketers or celebrities for your endorsement, often it happens that the celebrity is already in a valid contract at that point of time with a competitor. So while you are engaging a celebrity to promote your phone, Apple phone, say for example, the celebrity is already doing similar promotion and marketing for Samsung. Now, in that case, it is very important whenever you are entering into such endorsement contracts, you take proper warranty and representations and indemnity from that celebrity or the marketing agency that if you're doing my ad, it is not going to violate any existing contract. Because that is a very, it becomes very critical, because at times you have invested so much so in the endorsement arrangement, also in your marketing and advertising, and suddenly realizing that somebody sues you for for breach of contract, and you being one of the parties who has against whom the relief is to be sought. So in that case, it is very important. So whenever you're doing endorsement agreements, whenever you're doing influencer marketing or collaboration agreements, appearance agreements, then you ensure that the celebrity is not under any foundation, any obligation to which restricts its involvement in your brand endorsement. That is one bit. Largely, it's we need to consider social media from both perspective, from both IP perspective as well as advertising law perspective. That's my 2 cents.
Thank you, sir. Sir, just a question for you that on the topic, if I am allowed to be a bit greedy, that there is an offshoot of trademark law which is called personality rights, the celebrity rights or personality rights. So recently there has been lots of cases which have been mushroomed up in which YouTube videos have popped up in which the small clips of these celebrities have been used by small vendors, sole proprietors, etc., so that they can making it look like that they're endorsing their products. So in such cases, how a person, a celebrity, as well as a small entrepreneur, can actually be proceed, and will it be a fair use for them if they are using just a small clip of maybe 10 seconds or something?
See, it's very subjective to the fact. Now, out of say a 10-minute video, somebody has used even for 10 seconds, but that use has a couple of things. If I look from purely from copyright aspect, a de minimis would apply here and say 10 seconds is, it's not enough to bring up a cause of action. But yes, if it is a clip from Sholay movie, right, which is a very very prominent clip where Thakur or somebody is standing, and that clip is used, which is a very substantial critical clip, that would amount to copyright violation, who and the violation of course of the rights owned by the producer, the movie producer. When it comes to personality right, if it is of Amitabh Bachchan or any of these actors being used to endorse your product, to show that they are endorsing your product, and because personality rights are human rights, they are not per se IP rights, they are commercial value to your personality, so they are very inalienable integral human rights. So person or the celebrity whose personality is used, whose likeness is used, whose images are used as part of the clipping, they do have a right to seek a pull down, take down of such kind of YouTube videos, because they are for endorsement of a product. They are not fair deal or fair use. Fair deal is personal use. So if I run a if I put a image of photograph of Shah Rukh Khan on my walls, that is okay. But if I now start endorsing my product in front of Shah Rukh Khan's wallpaper, like I saw, I think there was a Hrithik Roshan's ad or something where he was standing, and then these guys behind him, just walk through a hoarding or something. So that was, yes. So if I do that kind of activity, then it's a commercial activity, which is not a fair use, fair deal activity. So yeah, that is subjective to the facts per se, but yes, there is a violation of both copyrights of personality rights. But you have to understand who can bring up this cause of action, who has a list. Right. So the movie producer can have a list, also the celebrity can have a list.
Sure. Thank you, sir. Thank you for the enlightenment and the kind words. Now moving towards the answer, sir.
So much.
Sorry, sir.
Thank you so much.
Now moving towards Rohan, sir. Sir, we have seen that in the case of in the jurisdiction aspect in the trademark law cases has been rapidly been changed, because the presence of the person is not only limited to the physical, for the physical products or physically, but it has rapidly been changed to be available online. There are various social media websites which have the pages which in which they sell the products. So what the aspect with regard to jurisdiction have been changed in trademark law with coming of the internet age or the social media age?
Thank you, Rishabh. First of all, just a minute short of good afternoon to everyone. And hello to my co-panelists as well, and all the people watching. So, Rishabh, before I move on to the question, I just wanted to, a very interesting fact came to my, memory. Just continue from what Subhash was mentioning. If you recall, in the olden days when you did not have internet or social media, if you would go to those juice stands, you would see a lot of the celebrities' photos put up. You'll see an Amitabh Bachchan or a Shatrughan Sinha. And back there, you would hardly hear of anyone taking action vis-a-vis their image rights or personality rights. Uh, Compared to today, where you have an Amitabh Bachchan going to court for a declaration that his image rights or personality rights cannot be used without his consent. Uh, so much so, I remember it recently in January. Uh, Rajnikant came out with a public notice to this effect as well. So you see the change in terms of how social media affects compared to when they were not even concerned, when every kilometer, these images were being used by juice vendors or ice cream sellers. So there's a huge change in the way perceptions and confusion happens. Uh, Coming back to the question, in terms of jurisdiction, now there are two or three things to jurisdiction. Initially, jurisdiction was pre the 99 Act, and I'm not even going to the copyright because copyright has had this section for a very long period, what we know as Section 62. In 99, a section of the 134.2 was introduced, which changed the whole equation in terms of jurisdiction, because what we follow principally, and traditionally was what we know as Section 20, where the defendant resides or carries on business or the cause of action arose. However, the Trademark Act changed and said if the registered proprietor is also carrying on business within the court jurisdiction, the suit can be filed there as well. So it changed the whole dynamic, and we have various judgments on how 134.2 jurisdiction comes in. Now, that is one aspect of jurisdiction where the registered proprietor is based. Now, what has been read into 134 by various judgments of Banyan Tree and WWE, and there are now various judgments to this effect, is that online presence also confers jurisdiction on the court. However, how does that do that? Just having an online presence does not give, just because I am present online does not give Delhi High Court jurisdiction over me. Am I actively and passively? The test is purposeful availment. Am I purposefully availing the jurisdiction of the court? Which in practice means, am I selling or trying to sell to the consumer in that jurisdiction? Are you able to purchase my product or my service within your jurisdiction? If that is the case, then the court can have jurisdiction. Now it becomes interesting for brands which have a pan-India presence. That means any and every court across the country has jurisdiction, which was not the case earlier. And while this is the aspect of internet jurisdiction, after the IPR's Sanjay Dalia judgment, and then consequently the Ultra Homes judgment in the Delhi High Court, jurisdiction again has taken a very a different approach. That now what Ultra Homes has done is come in and give a distinction or draw parametry between 134.2 and Section 20. So it's kind of cleared the confusion of all these years, or I would say added to the confusion between Banyan Tree and Ultra Homes and Sanjay Dalia. There is a plethora of judgments now which give the court jurisdiction over a particular party, which in traditional way might not have had jurisdiction. Now, what was interesting a few years back, I think it was 2019, if I'm not mistaken, in the Patanjali case, where for the first time, I think the High Court went into a long arm jurisdiction in a trademark case, where I believe it was not really a trademark, but a mix of a trademark and a copyright and defamation suit, where the court directed all the intermediaries to seize the links, access to the links which were hosting the defamatory content. Now, the very interesting question came in is that the intermediaries, other social media parties said, okay, we will, by geotagging, stop the access in India. But the court said, no, when you're before me, I can also stop you from doing this worldwide. So, therefore, going beyond its jurisdiction and going into the long arm jurisdiction, which is not read into our statutes, unlike the US, the court injuncted these parties from also then stopping the links outside the country, which was while this has been restrained by the division bench, but it would be interesting to see how this long arm jurisdiction is really read into. Now, this is primarily where we are at. So, how internet jurisdiction now really works. Like I mentioned, that purposeful availment means that you are selling the product or the service. Now, what a party usually will have it as a defense is, I do not have a registered office, or I do not have a subordinate office within the jurisdiction of this court. But that is not relevant anymore. Even if you do not have an office, but you're selling goods through the internet medium, and I'm able to purchase and receive goods. Now, this is very important, that are you selling the goods, or are you looking to sell these goods? These are the principles that the court needs to look into and see that if I can purchase the good and show to the court that, see, this is my office in Delhi where I got this good. Therefore, this company is liable to the jurisdiction of this court. Now, what Ultra Homes has done is, going beyond this, has created 4 parameters on how the courts can have jurisdiction. It has basically read down 134.2 and said that if you do not have, even if you have a registered office, but you also have a subordinate office where the defendant is based and you're carrying on business there, therefore you should file the suit where you have subordinate office and where also the defendant is based. So it kind of reads section 20 into 134. And it kind of creates a quandary that, which court really has jurisdiction. Now, the other interesting aspect of jurisdiction is, when we're talking about internet jurisdiction, is now the coming in of the metaverse. We've had cases recently. Now, metaverse, again, is something which is usually accessible across the world unless you're only catering to a certain country. And we have heard of various cases of, I was recently hearing a case in the Delhi High Court where it was an NFT case and they had come to the court. Again, it was an NFT trademark infringement, probably one of the first few in the Delhi High Court. And the interesting question was, how does the court have jurisdiction? Is the metaverse accessible? And it might go against the already established principles of jurisdiction that we know of. So it's a very evolving landscape, especially, I believe, in terms of long arm jurisdictions, because neither our CPC, neither our IP laws deal with long arm jurisdiction. But with the advent of internet, we have gone beyond the jurisdiction of the court. If you would recall, in other places like maritime laws, a country does have jurisdiction even on waters which are Indian territory, but you might not have jurisdiction over maritime where it belongs to another country, but that was on a physical piece of land or water. Here we are talking about how do I restrain, even in domain names, for example, you have registrars which are not based in India. And in a recent case, which I believe Abhimanyu was mentioning earlier, The court said that if you're carrying on business in India, even if you do not have a physical presence, does not matter. If you want to carry on business here, you need to comply with the laws here. So this is, in a way, a long arm jurisdiction. Our courts are going beyond that. If you want to carry on business within the country, you are bound by the laws of this country. And I think a very celebrated judgment in terms of intermediaries was also the Christian Louboutin Nakul Bajaj judgment, where the court said that, if you're an intermediary, just a section 79 will not really help you. You need to show that there was no involvement at your level. And if there was involvement, you cannot say that I am based in the US. You are carrying on business. Today, most of these social media platforms probably have the largest user base from India than even in their home countries. So they know that India today is the one which is really giving them, I would say, more commercials or more money. So therefore, they know that they cannot escape the jurisdiction of this court. So, I mean, just in a nutshell, jurisdiction is something which is very interesting and case to case can differ. So, that is again from me, and thank you, Rishabh.
So I have one question which relates to it, is that you can see the example of the PV Sandhu, where she has sued the various companies for ambush marketing, where in the garb of basically congratulating her, there has been a lot of marketing being done, and that's been seen something which is very common, and the IPL which is going on these days. So many people and many companies do post on the social media with the IPL and the other aspects related to it. So what do you think that is our trademark law is sufficient enough to deal with such social media challenges which are being posed, or what can be changed for the future endeavor in this trademark?
Thank you, Rishabh. So, in terms of ambush marketing, we have had ambush marketing, and ambush marketing is primarily sports related, majorly. I would say 90% of ambush marketing is in relation to sports events or sports personalities. Now, much before the social media came in, or internet was still there, the first judgment that the Delhi High Court dealt with, and I think that was the first judgment in India, was in 2003, which was ICC versus RV Enterprises, which dealt with ambush marketing. Now, ambush marketing was only in relation to a sports event, and if I remember correctly, in 2003, it was in South Africa, the Cricket World Cup, and this company, I believe, was not the official sponsor. Now, what happens in ambush marketing? One is, like you mentioned, personality rights. Two is also the commercial arrangements. In certain countries, ambush marketing is statutorily recognized, but in India, it's again a court mandated right. Now, if let's say, for example, Pepsi is the official sponsor, but Coca-Cola says, okay, if I'm holding a contest and if you win, I'm going to take 50 of you to see the World Cup. And then when you go to see the World Cup, you will see on screen they're wearing T-shirts showing Coca-Cola, whereas Pepsi is a sponsor. Now that's ambush marketing. That's one way of ambush marketing. And it's very similar to what you call surrogate advertising for alcohol brands, like Subhash was mentioning. So we already have various case laws, especially in relation to sporting events, in relation to ambush marketing. So I believe the same principles can apply in addition to also bringing in personality and image rights. Now, there's a fine distinction you need to draw, because if I'm congratulating, let's say, a PV Sindhu for her achievement, there is no commercial angle to it. It's a congratulation to a fellow Indian on her achievement. However, if brands start using it in a manner that has commercial ramifications, then yes, certainly, that is a cause of concern, and they are trying to bank on her goodwill or her image. And the reason it's a concern is, let's say a PV Sindhu represents a brand and a competitor comes in congratulating her. These could also, contractual issues could also arise out of that. So there are various issues that one could go into, and ambush marketing is just one aspect of it.
Thank you, sir. Thank you all of you for taking out time in this lazy afternoon. I am doing this session. I hope it was not so boring for you and as well as for the participants. And we continue to seek your guidance and support the IPS store. We thank you all for the IPS store coming to this session, and I hand over this to Rishita. Thank you.
Thank you.
Thank you, sir. Thank you, sir. Thank you for such an insightful panel. And it was a great learning experience for me and as well for participants also. And now I would like to thank our panelists for taking out their valuable time and joining us today. We are grateful. Thank you to all the participants. And our next session will begin at scheduled time. Thank you, everyone.
Thank you so much.
Thank you,
Thank
guys.
you.